Okay, let's go. Everybody's awful quiet, so again, that means we'll just start, huh? Welcome. We are very pleased to have a guest speaker today who's a true expert in this area. So I will quickly hand it off to Bob Crouse, who's with Myers Bigel, one of most respected law firms in the area for patents, and internationally and nationally recognized. Certainly, I've known two of the, I guess, Mike Sedgbeck is a partner as well. I've known a couple of partners for probably 23 years or so, and actually had utilized them for some patenting work I did in the industry. So we're very fortunate to have you take your time today. Really appreciate it. But before I give it over to Bob, I want us to talk a little bit about why we care about patents. And you all should know that now very well, I hope. If you saw my email from Sakai, how many people saw the email? Excellent. How many people read the email? Come on. Yeah, come on. Now I know you're lying. Okay, what's been in the news lately? Give me some examples. Is it any IP stuff in the news?
Samsung and Apple.
Yeah. Samsung versus Apple? Any? Give us two. That's about it. Who won?
You don't which.
No. That's certainly not true. Somebody won, right? I think the attorneys probably won.
Consumers lost, Apple lost, Samsung lost.
Okay, why? Why do you say that?
It reduces competition. I mean, it's a long lawsuit that just kind of didn't solve anything really.
So long lawsuits, great, and a lot of times these I mean, great analysis. It's a long, the length of time of these lawsuits is tremendous, and many times when we see the headlines that say, so and so won lawsuit, that's not the end of it, because then there's an appeal, and the appeals can go through multiple appeals. So it is extremely expensive, takes a very long time, not always a clear-cut answer, right? But why then is it important? Somebody sort of won in that, right? Well, let's wait. We'll table that and let Bob talk about that later. What other examples?
Well, Microsoft just brought Nokia,
okay.
And then you can imagine a lot of their what they saw in the company was the patents they have, and they want that technology.
Great example. Many acquisitions are not driven by a specific product, but driven by intellectual property. Both the brands and the trademarks / patents / intellectual trade secrets, and even a lot of times recently, especially in the news, we're seeing companies buying smaller companies strictly to get the people, right? So you can really wrap the people up into that intellectual property as well. It's not that the products that the company's delivering are that special, but they need the people that are in the company. Good. Other examples?
More in general, you have like a lot of stuff about troll patents.
A lot of what?
Like troll patents.
Okay, there's a lot in the industry about that now.
Like
yeah.
Obama, I think, is trying to pass legislation to stop those firms.
Yeah. So one person's troll is another person's legitimate intellectual property, right? So, but there has been a lot of negative press about patent trolls. And I don't know that we'll get time to go through that today, but certainly it's something to keep in mind, especially as a startup, because many times startups get caught in that, and it can make or break a startup. Another example?
Oh, no.
Okay.
I think there was something about Oracle and Google a while ago, because my comp sci professor, I remember, was testifying on Google's behalf.
Okay.
And I think it was an IP battle. This was about a year ago.
So, I think what we want to take away from all this is any given week, any large company has probably got a patent litigation ongoing, right? If I look at just a few of the examples, so I only went 1 week back, right? So first of all, put it in context. Patent awards keep rising. 7 topped 100 million. 3 were the largest jury verdicts of the whole year. And 11 were the top 50 were patent infringement cases. So lots of money, lots of expense and time is involved in this. I'm just going to really zip through these. Google, Cisco, and TiVo. 490 million went to TiVo. I put that in context. TiVo's profit for the quarter was only 268 million. All right, that's $500 million. Now that was August 27th, August 25th. Microsoft Corporation takes on Google's Motorola Mobility Unit in a lawsuit, and they say it was a breach of contract due to intellectual property that should have been allowed. They should have been allowed to license, but weren't. August 28th. So remember, these were all in 3 or 4 days of each other. All the big companies. Here we have an Apple remote locator systems lawsuit. and Johnson & Johnson and Abbott. So all this, again, within the last week was in the major news. So having said that, we just want to convince you all to listen up and think about intellectual property as a major business issue. It's not just a technology issue. It's not just an issue of, do I need to understand patents because I want to be a patent attorney, but it's a huge business issue for every company now, essentially in the space we're talking about, technology-enabled companies. So with that, I'm going to turn it over to Bob, and then he can really answer detailed questions on it as we go through. And I know he's got some great examples and a little exercise for you all to take a look at.
Okay. Well, let's start. I'll tell you who won, because I represent Samsung. But I'll tell you what the Koreans think. The Koreans think they won because they got Apple's attention. And it took a long time to find them liable. And $1 billion is a lot of money to Samsung. Whether or not they make a lot of money because they're worldwide. Compared to the iPhone, for example, when Apple wants to roll out the iPhone, it takes them 6 months, 9 months to get it worldwide. Samsung has it worldwide overnight. They can distribute in Africa, Asia, Europe, Russia. They're everywhere at once. So the way Samsung sees it is that they were able to get into court with Apple. Apple had a very vicious knife fight with Samsung, which still isn't over. And in the legal context, you could argue that Apple won and Samsung lost. But in the public perception, I think, is people look at some of these things.
I'll already go out of order here.
Perfect.
They look at some of these things, and the public says, "You can get a patent on that? You've got to be kidding me. That's innovation?" And so it almost looks like it's kind of a scam. If you really don't know what you're looking for, it looks like if that's what it means to be innovative, maybe Apple isn't all that innovative from an intellectual property standpoint.
So even though the verdict officially went against Samsung, if we think about business strategy, Samsung really won.
They won, I think, in terms of the public perception.
Yeah.
And also, worldwide, they did score some victories. So, and it's not over. They will go, if you know anything about the Korean War, you know that you never want to get involved in Egypt. So they will never give up. And also, they're very emotional, and they've essentially told me it's very upsetting to them to be accused of copying things, that they're not doing their own innovation. And you could have a difference of opinion over that, but that's what they believe. So that was their view. So anyway, that's who won. And then I'll say one other thing about trolls before we get started, because there's nothing in my presentation about trolls. If I gave you a list of companies, some people would argue, like for example, IBM, troll or no, not a troll. Arguably the biggest troll of all of them, because some people define troll as a company or entity that doesn't make what they're enforcing. IBM really doesn't make a lot of things anymore. They do software, they don't manufacture, they do basic research in chemistry and physics, things like that, but they're not making a lot of things. And so if you define troll that way, they're a troll. Ericsson, another client, they don't make base stations anymore, but they sue on base station patents. Is that a troll? Volumetric Medical Imaging, that was a Duke startup that I represented, wrote several, 6 or 7 patents for, maybe more. They sued GE, Toshiba, Siemens, Medison, every ultrasound manufacturer, because they were put out of business through deceptive and fraudulent practices. All they had left was the patents. GE called them a troll. They should have killed them when they had a chance, because they eventually beat GE in court. Because sometimes all you have is what you invented. So these things, and we're talking just about patents here, but it really applies across the spectrum. Copyright, patent, whatever you're talking about in terms of your property. Sometimes it's all you're going to have, especially as a small company. And it may be the thing that actually levels the playing field. Because as unfair as it may seem, being in court, the playing field is far more level than in the marketplace. Because in court, the judge and the jury have all the power. And it's you against them, and there are very few people really on the scene on each side, compared to in the market where it's really not a fair fight. And if you've been in business, you know how true that is. Okay, so what is it? It's like any property. If you own a home or a car, it's like that in the sense that when you own your home, you also own the right to live there and not to be dislocated from it, not to have people trespass on it. Real estate includes not just your home, but the property. So that right is like patents, copyrights, any intellectual property. You have the right to use it, you have the right to sell it, and you have the right to eject trespassers. The one important thing to note, too, is that if you are going to the trouble to get this intellectual property protected, you want to make sure you actually own it. When you buy your home, you want to make sure that the seller actually owns it. It happens a lot, and especially in patents, where it's not the first question litigated was whether or not the patent owner actually owns it. Volumetrics was a good example. Volumetrics sued GE and the others. The first year, $1 million in litigation was over whether Volumetrics actually owned the patent. After that, when that was settled and they determined Volumetrics actually did own their patents, GE settled. So it's important to make sure that you own these things. And I'll explain maybe today, maybe Thursday, a little bit more of that. But it's so, and there are quite a few pitfalls if you don't look after things properly. Sure.
How would you, can you elaborate more on intangible property?
Intangible property? Intangible property would be something that you can't hold. So the right to eject someone, that's an intangible. Or the right to sell it, that's an intangible. It's not a property in the sense that your car is a piece of property, or your dog, where it's a physical thing. So
would human genes fall into that category?
if it was patentable, some may be, and I'm not an expert in that area, but then we'll go into that a little bit, that if it's something you can make, and it doesn't exist in nature, then you can probably protect it some way. There might be different ways to do that, but anything else? We might skip over some of these slides. So these are the biggest categories of protection. And each of these categories really is mostly aimed at a particular type of property or a particular type of invention, if you want to put it that way. But they're not necessarily mutually exclusive. They can overlap, they can coexist. Some can be covered by all of those. So one thing could be covered by every one of those, maybe more than one, maybe 3 out of 4. So each of these has a different purpose. And this is really the most important question, as opposed to how is something protected. It's why would you protect it? So in other words, you have all these categories of protection that you can maybe get on something. You want to make sure that the protection you're trying to achieve lines up with the thing you're trying to protect. And what that really means is that it should really dovetail with your business objectives. So if you're going to be distributing software, for example, you might not focus so much on trademark, or you might not focus so much on trade secret. There might be other ways, better ways to protect it. So you want to make sure that whatever your business objective is, your intellectual property, and you'll have lots of it, your intellectual property protection is tuned to the business model. So if you're going to be doing base stations, does everybody know what that is? Like a cell tower and the infrastructure that goes into mobile communications. If you're going to be doing those, you may want to get patents on the actual hardware that does the switching. You might want to get patents on the air interface. That would be support your business objectives. You wouldn't necessarily want to get patents on handsets,
You might, but you may not want to get handsets. So that's what I mean. You may want to, you're going to need to look at what's the objective I'm trying to achieve and what are the best ways to do that and forsake other means because they're all expensive. So just to summarize, trademark, that's like something you might see, Coca-Cola, Gillette, these types of things, these symbols, the colors, and other things we'll talk about. This is Apple, of course. Where is it? If I showed you this, could you tell the difference? If I viewed this far away, could you really tell the difference between a Galaxy, is it an S, and an iPhone? I couldn't. And so we'll talk a little bit more about that. But it basically helps people distinguish between that's this source versus that source. And the problem comes there is confusion. If consumers are being confused, that's what you want. You want trademark protection so that you can stop other people from using something that's so similar to your mark that it's confusing them into buying products that aren't yours. Copyright, that is to protect you against literally copying. So that's very narrow, meaning if one of the two elements of copyright are access and copying. So it's not just enough that somebody has something exactly the same as yours. You have to show that they had access to it. In other words, if they invented something exactly the same as yours and they didn't have access, that's not copying. That's just bad luck or really, really unlikely, but still just bad luck.
Or good luck.
Or good luck, yeah. We actually had a case where statutes can be covered by copyright, and the copier actually did such a great job of copying the statute. Our client's copyright mark on the bottom was actually in theirs. So that's a good way to show. We couldn't really show they had access, but there was really no other way for them to have that, other than to have access. Trade secret, that's where you just try to keep something secret as long from the public. Coca-Cola is one of the classic examples of that. Coke was rumored, the formula for Coke was rumored to be a secret, still a secret. The chemical composition, how they make it. That may or may not be true, but it actually adds to their brand. And that's something that everybody, or not everybody, but a lot of people are interested in those kind of things, believe that it's a trade secret. It adds to the value of their brand or the product. But what you're trying to do there is you're trying to avoid the public from ever getting access to it. So if you're into having it locked up forever, that's where you want to go. That's really the best way. There's other ways to do it, but that's really the best way to do it, the most straightforward way.
Is trade secret actually an official term, and is it actually an official protection, or is it just something you don't tell anyone?
It's official in the sense that you don't register, like say, where you don't apply for a trade secret like you would apply for a patent, or you don't register it the way you would register for copyright. But you would just go, to whatever lengths necessary to try to protect it. Like Coca-Cola, their model was only a certain number of people actually knew the formula. Why they had to know it was beyond me, but a certain number of people had to know it. It was locked in a safe. Only 2 people had the combination because safes never get broken into. We know that. So they're going to some length to try to protect it from becoming public. Okay, but the problem with trade secret is if someone can figure out how to reverse engineer it,
It's no longer a secret.
it's not going to be a trade secret. Otherwise, if you have a trade secret and I take it from you, either you share it with me and it's under non-disclosure, I publish it, that's a misappropriation. And that's could be covered by federal criminal law, I could go to jail, or state trade secret law. It's different in different states, but you don't want to break trade secret law in California.
So litigation is mostly like remedial in the sense that the damage is usually done by the time it's out, right?
Yeah, I mean, you're right. If by the time it's disclosed, if there is any value to the trade secret, it's lost. However, it doesn't mean you couldn't have other claims against them. Like we could have trade secret claims, but you might have other claims as well, breach of contract, things like that. So that's why trade secret is a little risky,
Because if someone can figure it out, for example, this is just getting way ahead, but this, so trade secret,
Pull that up.
sure, if you could, I'll just hand this around. This is a cover sheet of a patent application filed by Coca-Cola. It's in patentees. I think it's actually the sweetener that goes into either Coke Zero or Diet Coke. It's fascinating reading. And
I said I could, and now
okay, it
it's
doesn't really matter.
gone.
But consider this: if you if you file an application and it becomes public, or it becomes patented, it becomes public, it can't be a trade secret. Okay? So you have these two competing ideas for the same. So let's say it's the same product. You have this where it's going to become public. You have this, the historical way to try to protect something like that, keep it secret. If you go this way, it's not going to be a trade secret. If you go the trade secret route, you can't patent it. That's where the two are in tension. So there's this, Coca-Cola, there's that, Coca-Cola. And I think what's really going on is that reverse engineering has caught up. So now it's much easier to figure out what the composition of a compound is. Our client, Samsung, regularly will, this is different, but they'll take the top off an IC. They have no problem trying to figure out not only what the circuit does, but how it's made. So the reverse engineering business or technology is far, far greater than it used to be. So if you could just scroll down to some of these graphs. So what they're doing is they're describing, I mean, there's lots of this material in there, 62 pages. It's for a food chemist to be able to make this. So they have to show a food chemist of ordinary skill in the art how to make this sweetener in order to get the patent. That's how it works. But once you do that, it's not a trade secret anymore, which means that eventually this patent is going to expire. It's going to be free for everyone to use. Okay? So that's the trade-off. Again, not everything. If something's easily reverse engineered, you don't want to go the trade secret route. All they have to do is take the top off. Yeah.
What's the timeline for a patent?
Patent can be anywhere from, in the U.S., I've gotten them in as little as 3 months.
I mean, like, how long does it last for?
Oh, 17 years from the date of issues. In a utility patent, like something like that.
Yeah.
So, yeah.
You said patents, like usually companies will try to buy a patent, like companies just with patents. Is that the same situation with like trade secrets, or will they just try to reverse engineer it?
I mean, it's like a piece of property. If they could try to reverse engineer it, or you could just buy it. It's an intangible piece of property. You could buy it to the owner.
Okay.
As long as they actually own it, then you're in business, so to speak. So that's really the point here, is that each one has its own advantages, but it has their trade-offs for each one of these as well. Once you go the patent route, you're giving it up one day. But you might decide, you know what, in the electronics business, 17 years from now, I'm going to be on my yacht, and you can have it. Trade secret, you may lose it tomorrow if you get somebody clever enough to reverse engineer it. So sometimes you can get both, like if you're in software. Okay, so just to briefly run down, utility patents we've talked about, that's the utility patent type that I pass along. Design patents, we saw one of those just a moment ago. We're going to look at it again in a second. Plant patents speaks for itself. I don't know anything about plant patents, but it's big business. Monsanto is a big company that loves plant patents. Anybody, if you know anything about the, called golden rice? I think it's called golden rice. Everybody know what that is? Golden rice is a genetically engineered rice, and the idea is that rice is a staple for much of the world's population, and the problem is it doesn't have vitamin A. And so when people don't get a vitamin A, there are maladies associated with that. So they engineered vitamin A into this golden rice, and that's a plant patent. They also Roundup, there's a seed that incorporates Roundup into it as a pesticide. That's a famous plant patent as well. So they actually will graft these or incorporate some of the components of other things. It wouldn't even necessarily be a living organism into the seed. Okay, so this is a design patent. Okay, so design patents cover ornamental aspects of something that's functional, like this, right? Like the iPhone. So if you look at this, in case you can't see, this is the Galaxy, this is the Samsung, that's the iPhone. So one of the things that you hear a lot about is this criticism we talked about earlier, where people say if you can get a patent on that, how does it mean anything, and how could that be enforceable? But one thing you have to understand is that when you hold this thing up, and they actually do this, I'm sure, hold this up, the design is such that they know what people see. They see the whole thing, but they don't see everything the same. So designers really know what people cue in on. These design patents are written specifically for that. So again, the business model of looking at the product, what is it that people love about looking at it? What is the design, a part of the design that they find appealing? And then going right for that, trying to protect it. Say, that's the thing that everybody is going to want to copy. And in that sense, I think Apple was right. They invented this format, a phone, I think, for a smartphone. And, you can see why the jury said, yeah, I mean, that's really close. And the standard here, it has to be substantially similar. Okay? So, if you note, this is really technical, but these dotted portions, see this, the home button, the back, where the speaker is, those are portions which are not covered. They are specifically saying, we're not claiming that as part of our design. So when you compare these two, you can't look at that. The fact that this doesn't have the same type of home button doesn't matter. The fact that it doesn't have the same speaker doesn't matter. It's only those aspects. So the way they sort of abstract it is, it's the bezel. It's the bezel with the screen shape, this part right here. It's those two elements in combination. That's what defines the iPhone-ness of this thing. And that was a winner. That Samsung was actually held to infringe this by the jury. There was another patent, which I don't have here, which is more controversial, which everybody got really upset about because it was interpreted that Apple had covered rounded corners on icons or objects, which is not, I don't think it's true. I mean, everything has rounded edges if you look at it closely enough. But what they're really doing is that it's the entirety of it. So if you look at that patent, and you can look at it now and know it's the entirety of it. Anything that's not dotted, that's what you're trying to cover. So it's the entirety of all these elements that aren't dotted. There has to be substantial similarity between the device that you're comparing to it and the patent. So when you really look at that other Apple patent, that's a patent on a graphical user interface, not on icons per se. So that's one of the things that gets lost on NPR, for example. Or any place where they're really talking about patents and they don't have the time to really go into the details. We talked about this. Patents give you the right to eject someone. You also have the right to sell it. What can you patent? Pretty much anything you can manufacture. Some things you can't, as long as it's not naturally occurring. An algorithm, what else? Well, an algorithm or law of nature, things like that. Can't patent that. Too bad. It just can't be obvious. Has to be new, can't be obvious. In the U.S., the standard is really read as it has to be different, has to be new. Obvious, that's really up to the patent examiner. Okay. And here's one thing, this is a little side note. Everybody, I know people like to talk about patent policy. They talk about trolls, and should software be patented, should it not, should it be patentable just like anything else? And it's always good to have an idea of what policy we're trying to achieve or support. But consider this, too, that the real, and there are problems with the U.S. patent system, and I think this is the key problem with the patent system. When a patent gets out of the patent office, when the examiner issues it, it has a presumption of validity. And what that means in legal terms is that to invalidate it, you have to show what's called clear and convincing evidence. So, in the scale of evidence, preponderance of evidence, you watch, Boston Legal or whatever. Preponderance of evidence means 50-50, more than 50%. Then there's beyond a reasonable doubt. That's 99% plus. And then there's clear and convincing, and there's other ones too, but clear and convincing, about 90%. So think about that. Patent gets out of the patent office. The examiner may not really have that much time to properly examine it. He may not get access to the best art, the closest art. And she's completely outgunned. She's got 50 lawyers teamed up on her trying to get this patent to the patent office. Once it makes it out of the patent office, it has a presumption of validity, which means it's really hard to knock it down once it's out of the patent office. If you recalibrated that standard, you would solve a lot of these problems. Trolls would not be in the casino business, which is basically what you're in. The only people that would be in the business are the ones who have a real vested interest in the outcome. Meaning, I have a product or an investment in this thing, I am going to defend it. And some countries, what they do is you just register your invention, and then once you decide to enforce it, then it gets examined. And then it gets a very substantial examination. So the European Patent Office tends to be like that. Examiners make more money, they're more highly trained, they generally have graduate degrees in the area that they're working in. That's my criticism of the U.S. Patent Office. It's relatively easy to get a patent. It's relatively easy to get a broad patent. But enforcing it, that's another matter. That's where the real action starts. And that's where the real expense starts. You also need to be able to describe it adequately. That's usually a very low standard. Okay, so when we talk about a patent, this is what we're talking about. This is at the end of the patent where the claims are. This is what everybody worries about infringing. So this is the language of what a patent claim looks like. It's really hard to read. It's one sentence. It's has sort of very archaic language to it. Very sort of weird syntax. There are lots of legal rules on how to read this. But this is basically how it works. If you make pencils, you have to, if this patent issues, what you have to do is sit down and say, do we have a hexagonal wooden shaft with a cylindrical core? Yes or no? Do we have graphite in the cylindrical core of the hexagonal wooden shaft? Yes or no? Now, a lot of these answers are not yes or no. It's maybe, or sometimes, or I don't understand what that means. But that's the objective. That's the exercise. If you get to the end of this list, and the answer is yes to all of the questions, then you have a potential problem. Okay? That's when you could be infringing the patent. So, but that's not the end of the exercise. Then you go to the design engineers and say, do we need a hexagonal wooden shaft? Could we make it round? What about graphite? Do we need graphite? Could we put depleted uranium in there? You know, and believe me, it's going to shut your business down. You will go to great lengths to try to avoid this patent. Okay? Do we need an eraser only at one end? What if we eliminated the eraser? Any of those, except for the uranium thing, it's probably a viable workaround or what's called a design around for the patent. Yeah.
Do you only have to say no to at least one
Yep.
to be okay?
Not only is it just, it's not even, these things are bracketed off. It's like closets where the semicolons are. You don't have to say no to that entire portion of the language. You could say no to any one of those. Oh, it doesn't, we don't make wooden. Or what does wooden really mean? What if we have plastic in it? Believe it or not, that's a legitimate question. Because if during prosecution, if I'm the guy trying to get this patent through the patent office, and the examiner shows me something that is truly wood, says this is the same as your patent or your claim, and I say, no, that's not what I mean by wood. We have a certain level of plastic infused into that material. That's what we mean by wood. And the examiner says, okay, if that's the case, then I'll let you have your patent. You're not allowed to then go back and say, wood means wood. You're stuck with that. And so when you go to your patent lawyer and say, do we have a problem with this patent, the patent lawyer would probably say, well, is there anything in your hexagonal shaft other than wood? If they say, no, could you put something in other than wood, like plastic? Or could you, I'm sorry, it's the other way around. You don't want plastic in it. Is there anything in it other than plastic? No. Then you're good. You're clean. You don't have to worry about it. So any word is a potential loophole. That's why generally the shorter a claim is, the more problems it presents for a product manufacturer or someone who's doing something. It could be covered. But it's also more likely it could be invalidated. In other words, we say this patent issues, it has a presumptive validity, then I'm, who's the big pencil manufacturer?
Ticonderoga.
There you go. Ticonderoga decides we're going to take this patent down. And there are many options there. One is to go to court and say, we want to go to court, we're going to fight this out now and prove that this thing's invalid. They have a very high standard of proof that's their burden, but they may have references that are dead on, that show this was done 20 years ago. Remember Samsung, one of the things they did in the lawsuit, they presented a notepad from 2001. The image of I think it was the iPad patent that they were arguing over. They showed a video from 2001 Space Odyssey where they were using these tablets. And they said, that's the same as the iPad. Because you're not talking about how it works, you're talking about how it looks, and that's the same. I don't remember if that was successful, but it's a good argument. I mean, that's creative, but that's what $20 million in legal fees will buy you. And you got people watching movies just to try to find prior art. But so the broader you make it, the more likely it is that there's going to be something done previously which is the same or close enough to yours to make it obvious. Doesn't have to be exactly the same. Could be it's exactly the same except there's no wooden shaft in the prior art, a wooden shaft with plastic. Is that close enough? The jury might say yes, that's close enough. That meets the standard of clear and convincing evidence.
Can I add one thing here? What I've also noticed is, as engineers, we think we're pretty smart, right? So we read this and we say, we can interpret these words. Well, the words don't have the exact same meaning as we might think of them in our engineering profession or in the layperson's profession. They have been defined, as Bob said, through the patent process, the prosecution process, where they get the patent. So I've been involved as an expert witness in cases where when I first read the patent and took the case on, I thought, this is pretty straightforward. Clearly, this is not an infringement problem. Then you get in, you see how they actually defined each of the terms when they submitted the patent, and you're like, wow, that makes it much stronger patent.
Okay. So some of this we'll skip over. You don't have to worry necessarily about how to go about doing this in the best way, other than to really read. If you get a position where you're reading patent applications, I know it's painful, but you want to really read it, really think about it, because a lot of these people who write them don't know much about the technology. They'll say something stupid, and if you don't see it, it's really. If you've ever heard the term, everything you say will be held against you, it's never more true than in patents. Because once this thing is done, once it comes out of the patent office, you're stuck with it. You can't go back and rewrite the description. If you say that your pencil, if you say in your description, not in the claim, but in the description, you say hexagonal is three-sided, then you're stuck with hexagonal means three-sided. It doesn't matter what hexagonal means in the art, you've redefined it. So, you have to be careful, because everything you say will be used against you, especially when there's a big competitor on the other side.
And there are hundreds and hundreds of pages of the file for the patent, for every patent that's issued. In other words, the patent office has all the communication that went on between the person filing the patent and the patent office. Now, as an attorney, if you're in litigation, you go through that entire file wrapper, they call it. I don't know, how many pages typically is in a...
It depends. I mean, they can be hundreds of pages, but also now that we're in the patent office considers this to be in the 20th century, you can actually go to the patent office website and see all the prosecution for any patent that's public, so, or any patent application rather that's public. So if that case that I passed around, if that was undergoing examination in the patent office and it had been published, which means 18 months after it was filed, anybody can watch what's going on. You can see the arguments that the lawyer makes. You can see the arguments the examiner's making. You can send in your own stuff if you so choose. Yeah, it's a pretty open system. Still has some serious problems, but it's more open than it used to be. Again, patents, you want to watch for a lot of different stuff, but two big things you want to watch for is you don't want to disclose something, meaning put it on the internet, give a talk at like a technical conference, put it in an IEEE article, things like that before you file a patent application on it. The rule is, in the U.S. you have 1 year to, if you disclose something today, and you have 1 year to file your patent application. But in Europe, you're lost. You're never going to be able to get a patent on it. So most jurisdictions like Europe, Japan, Korea, they have an absolute novelty bar, which means that as soon as you disclose it, you can't patent it. U.S. gives you 1 year, and Canada as well. So the other thing, again, you want to make sure that you actually own it. And that can be sounds easy, but it's complicated sometimes. Copyright. So copyright is a pretty old area of intellectual property. It was primarily designed to protect authors or artisans. It's really been stretched mostly in the areas of music and software. So some of what I'll talk about here, most of what I'm going to talk about, is going to be software related. Compared to a patent, copyright is achieved once you write it down, once you put it in a fixed medium. If you program a part with executable, you have a copyright on that. If you create a statue or a painting, there's a copyright exists in that. Your right, you own the right to copy that work. That's, again, as an intangible, it's separate than the work from the work itself. So consider, if you sell the painting, the buyer doesn't necessarily get the right to copy it. They get the painting, but you own the copyright as the artist. And generally that's true in all these areas. The inventor or the author owns it until they do something with it. Again, same sort of rights that you have as with patents. You can control it, you can eject people from using it, you can sell it.
One thing I found that confuses, again, technical people a lot of times is once you have a patent, that doesn't mean that you can actually make what you patented. There might be another patent that prevents you from doing something in that process. So what that patent gives you is the right to exclude others from doing anything in that patent space, but it doesn't necessarily allow you to make what you patented, because there might be another umbrella patent or a patent that covers one part of your process that excludes you from doing that, and that's where you get lots of cross-licensing and deals on patents.
Yeah, that's true. I should have mentioned that. And that happens a lot, especially if it's a complicated, it's an automobile, computer, there are lots of patents, but usually the market deals with that is they create pools of patents. So, like a standards agreement, that if you're going to design cell phones for CDMA, if you buy into the pool for CDMA patent, anybody who has anything to do with the definition of that standard agrees anything they get as a patent on that standard, they will offer on fair and reasonable and non-discriminatory terms to anybody who wants to be in that business. So, in other words, they don't want somebody to sit in, this has some historical precedent, somebody sitting in the standards meeting, coming up with lots of great ideas on, this happened in the DRAM business, this company called, not Renaissance, I forget the name of the company. They sat in on the meetings to come up with the standards on how dual data rate RAM would work, really high-speed data memory, and contributed lots of great ideas. They were all adopted, and then they realized, oh, we filed patents on all those things. Didn't we tell you that? So, yeah, that was a big controversy in the standards area. It happened a long time ago, but it happened. Copyrights are connected, the term of a copyright is connected to the life of the author. Typically, there can be other ways to do it, but that's the primary way that, say, novels would be protected, or if you were writing software, it would be a work for hire, which means it really belongs to the company, not to you as the author.
Does that mean it's the company's lifetime plus 70?
Well, it's going to be 95 years
Oh, I
from
see.
publication. So there's been some controversy recently on Martin Luther King's "I Have a Dream" speech. That there was an argument initially when he made that speech whether it was subject to copyright, and they actually went to court. The family went to court to try to enforce it as a copyright, and it was a real issue in the case because he hadn't at that time. Once he made the speech, it was said to be a disclosure, so it was giving it away to the public. But the family, the estate, went back and tried to, no, we have a copyright. He had a copyright, and the estate then inherited that copyright, or the people, his heirs inherited that copyright, and it's a valuable copyright. Yeah.
Is the author's life thing also true for artists in general, like
Yeah.
painters and...
Author generally means anybody who's creating a work that's subject to copyright. So an artist, a software, a programmer, anybody who's creating something and it's going to be in a tangible medium, somebody who's writing a speech. So yeah, it's pretty broad. Okay, so software. Software, I know, gets people really worked up, especially in patents. But remember, copyright is really intended to protect against copying. And I guess you could disagree on this, but nobody in the United States copies software. No legitimate entity is copying software. That happens in Asia and places like that where there's very weak protection. If you were to copy software here, it would be a commercial death sentence. The damages are so high under the copyright statute that you'd be committing economic suicide. So now people do try to copy things they think are unprotected, like under open source or those kind of licenses. That's okay. It's not protected by copyright. They're giving it away, or they're offering a license to everyone. But copying has a legitimate purpose too. I mean, when you think of like everybody seems to have a zombie apocalypse movie or book, right? So the idea of a zombie apocalypse is not protectable. That's an idea. But the way the story associated with it, that is protectable. So the same is true with software. The idea of a particular module or function may not be protected by copyright. The idea is free for the public to take. That's the whole idea. Copyright, you have to give the idea away in exchange for protecting the expression. So the literal way that it's done. So in software, that would be the source code or maybe a flow chart, something like that. So you can't copy that, but you can take the idea. And there's no problem with that. That's the whole idea of copyright. But here's the thing I'm always puzzled by with software. Software is probably the easiest to protect because it falls into so many categories. You can patent it, you can get a copyright, you definitely get a copyright, you can protect it by trade secret, if you can try to encrypt it so that someone can't reverse engineer it. And this is the real atomic weapon of software protection is these end-user license agreements. I mean, anybody, if you've ever read one of those shrink wrap, clip wrap licenses, I mean, you can't breathe after you open that software. They actually make you promise. This is what's so weird about software protection under these end-user license agreements. They have a copyright, which means they're obligated to make the idea available. So in order to get the idea anywhere beyond just the obvious in software, you have to look under the hood. How did they do this? What's the idea of this module or this function? But this says you promise not to do that. A prohibition against reverse engineering is extremely broad. I mean, reverse engineering could be something as simple as just trying to look at this and say, how did this go together? How did they put it? That's reverse engineering. But that's what it says. You promise not to reverse engineer this. So
it's conceivable that software could be protected by a copyright, a patent, and a prohibition against reverse engineering. How anybody does anything that takes any idea or expression from a piece of software is beyond me. I mean, a lawyer would say you should just stay away from it, but I guess the flip side of it is it's very hard to determine if anybody's actually doing it. You'd have to go and reverse engineer the software, or at least look at part of it to know where did it come from. Yeah.
So I believe that Facebook has a patent on the newsfeed, and there's also a patent on like pull to refresh.
They have a patent on what?
The newsfeed. So the thing that you go to your Facebook and that scrolling list.
Yeah.
Yeah. Everybody seems to be doing it, including Twitter and a lot of other major companies. So how do you know when to ignore the patent?
Yeah. Well, the way that you would tend to know is you would go to your lawyer and say, "Do I have to worry about this, or is it the kind of thing they wouldn't?" Some patents they don't want to enforce because because there'd be so much common interest in taking it down that it would just go down. So another good example was the one-click, the Amazon one-click. That was one where they actually did try to take it down. Barnes & Noble tried to take it down, and they lost. And Amazon has that patent. So it can backfire that, but generally what you would do is you would go to your lawyer and they would look at, okay, as a good example, where's that handout with the computer, okay. So this is the way it generally happens. Somebody comes in and says, did you see Coca-Cola has a patent on high efficiency or high potency sweetener composition, yada, yada, yada. That's the title, but that's not the patent. So you have to look at the claims to really know what the patent covers. The patent could be a mess. It could be worthless. But the title looks sexy. You'll say, my God, they got a patent on newsfeed? How did they do that? Because they didn't. That's usually what the answer is. That's the most common thing I get from clients. How could they get a patent on that? Well, they can't. They didn't. You look at Claim 1, it has 100 elements in it. Because a lot of these companies, they're into mass, they're into volume. They just want a lot of weapons. So that they, like in Samsung, they get 3,000 patents a year in the U.S. That's just in the U.S. So they are into volume because they want cross-license, and cross-licenses are done based on volume. I have 10,000 patents, you have 8,000, we're going to cross-license, you owe me. That's how that business works. Yeah.
So I took a class on medical devices last year, and patenting seems to be pretty expensive in many ways because of the lawyer fees and
compared
other things.
to what?
I don't know, but like the process itself seems to be $30,000 to $40,000 for a worldwide thing. If you want to patent in Europe and other places as well.
Mm-hmm.
And so doing that for 3,000 or 4,000 things, 4,000 getting 4,000 such patents a year seems slightly. I mean, is it economical to do that?
Not at those terms, it wouldn't be economical, but the getting a patent is relatively inexpensive, actually, compared to like the number. I don't think I've ever done a patent for that much money. Would love to, but I never have. When I wrote the cases for volumetrics, those were $7,000, and I enforced those for 30 or 40 million. And I reminded them, you complained about the price of that. If you'd like, I'll give you a refund in exchange for some of the damages. But remember too that the patent, yes, it could be. Let's say that's true. Let's say it's a $30,000 event. You certainly wouldn't do that for all your patents. You would only do it for the ones that are really important. Like I dumped on IBM earlier. IBM is the master of patents. They really understand what they're doing. They play the game of where they just have lots of mass, lots of volume, but they are really good at going through and picking out the real corporate crown jewels. If somebody in Yorktown Heights is doing basic research in a particular type of transistor structure, they will protect that to the nth degree. Otherwise, if you're writing patents for IBM, they're paying you $3,000. That's what they pay for a patent, for a patent lawyer to write it. Actually, your kids could write it. They don't care. They're just not paying more than $3,000. Does anybody here work for IBM? No. I don't. But the point is that a lot of these guys, they have a sophisticated strategy. They'll say, this really isn't that important. Spend just enough to get something. Doesn't matter if it's really narrow. This is critical. This we have to get broad protection on. And they will spend, I've seen them, they will hand pick somebody. This guy right here in Minnesota, he's going to write this case. And they'll say, take the next 2 months, fly here, meet with the inventors as much as you want, write this case, write 200 claims. We don't care what it costs. Yeah. So, but it better be good. But it's nothing compared to enforcing a patent. One of the guys I went to school with, he handles Samsung litigation worldwide, and he's handling 60 litigations at any one time, worldwide. Generally, he's paying $6 or $7 million a case for the lawyers for infringement. That doesn't have nothing to do with getting the patent. That patent might have cost $5,000 to get, but it's $7 million to enforce. So that's where it really gets expensive. So when you're dealing with patents, as compared to some of this stuff, the real question to ask is, can I enforce this? Am I willing to enforce it? Yes, I can get it out of the patent office, and it might be broad. But remember, if it's broad, remember the volumetrics case. Volumetrics didn't spend all that much to get those patents, but GE was willing to spend $1 million to avoid and try to knock it out. And then they just licensed it. So as a way to actually control the cost. So the question really is, even if I get what I want, can I afford it to enforce it? Because most lawsuits settle. They don't go all the way to the end. Okay, so let's just go through trademarks real quick. Trademarks, like, say, protect this kind of thing, the symbols that identify the source of the goods. I have up here a couple of examples. Here's a razor by Gillette, the iPhone, and Coke. So what that really does is encourage people. It gives you a vessel to put your advertising into. See it on TV all the time, in newspapers. There's always attaching a symbol or some way to identify what it is that they're selling. Corning patent or tried to trademark or did trademark the color pink, believe it or not, or fiberglass. That's the way it works. Pink as to fiberglass, that belongs to Corning. If you were making fiberglass insulation and you tried to make it pink, you wouldn't get very far. The Pink Panther would be all over you. Harley Davidson tried to trademark the sound of their exhaust note. And it's really not that absurd. I mean, if people use it to identify what it is, especially when they're buying it, then you might be in the money. So again, what you're trying to protect yourself from here is somebody poaching on your mark, making it look so much like this that someone grabs it. There was a famous case in Korea. Starbucks was pretty badly ripped off by a company in Korea. They made the Starbucks logo. It looked so much like it. I actually went into one thinking it was Starbucks, and they lost in Korea. They actually, they said that the Korean coffee shop, that it was unique. So, even though you spend a lot of money on advertising, doesn't mean necessarily you're going to win. One thing, this is pretty interesting about trademarks. The more fanciful or arbitrary you make the thing that you're trying to sell, the more protectable it is, the more unique it is. Kodak is a good example. Has nothing to do with photographs, I think. The symbol might. They've got that thing that looks like a projector as part of the K, but the word Kodak doesn't have anything to do with photography or whatever the business is in that. Some are more, and there's a spectrum of something like that, and then there are marks like Apple, which are more, they don't really have anything to do with the product, the computer, but they're a known word. And they even tie it in, with the symbol of the apple. And then there are other, as you get more and more descriptive, the word or the symbol gets less protectable until it becomes totally descriptive. Of, if you're car wash, if you wanted to trademark car wash or car washes, you wouldn't be able to get that because it's too descriptive. They don't want to prevent people from saying, I have a car wash. And they're not going to let somebody own that and preclude other people from advertising their car wash. There are other ways that you can get into trouble, though. Xerox actually became generic. I mean, that was a name for, everybody used it as a way to describe photocopying. So that trademark was lost because Xerox didn't step in and try to prevent people from generally referring to the technique of photocopying as Xerox. Legally, it has ramifications. Sounds silly, but they actually take out advertisements now in magazines. Please refer to our products as, by the, Xerox is not a generic term. That is a brand name that we use to identify our copiers. That's what they need to do to protect it. Otherwise, you could lose it. It's sort of like you're a victim of your own success. If you become so synonymous with the thing, you run the risk of losing it. Kleenex is another example. Yeah, so Kleenex. Okay, so what I wanted to do, so let's just talk a little bit about trade. How much more do we have? Trade secrets. We've talked a lot about trade secrets here and there. Let me see, just pick out a couple of things here. These are some of the things that generally, okay, so great. So I think we covered trade secret, but I want to talk about just two more things real quick, just as an illustration. So this represents a sort of continuum of the Coca-Cola bottle from at least the earliest one that they could find that wasn't broken, all the way up to 1994. And so the question that really I thought of when I saw this was, which way would you try to protect this? Would you try to protect it with a design patent? Which it can be, because Coke has design patents on these. Or would you try to protect it as a trademark? Sort of the shape of this thing. When you go into I guarantee you will not see this kind of thing other than on a Coke or a licensed Coke product, something that Coke owns. So what would be, so to consider, you could get a design patent on this ornamental aspect of this functional thing, or you could get a trademark. Let's assume that that's true. Which one would you go for?
Does it have to be an either or?
Does it have to be either or? Maybe. Depends what you do. So think about this. What are the parameters of design patent? What's one of the major limitations of a patent?
It runs out.
It runs out. So if you have a design patent on something, once it expires, or once you don't pay a maintenance fee, could be 3 years, the public is free to use it. Trademark, as long as you police it, and as long as you keep investing in it, advertising, you can use it forever. And no one can get near it. So you want to consider that, as that's a fundamental, that ties back to what we talked about in the very beginning, was identify what is the objective. Am I trying to define something that is going to span from whenever, over 100 years? If that's what I'm doing, maybe I don't want protection that's going to expire. Maybe I don't want to get trades, maybe I don't want to put all of my eggs in one basket. So, for example, if you've got a design patent on this, and a trademark, and the design patent expires, which it will, somebody might say, well, let's say you want to make this, what would you say? Coca-Cola shows up and says, hi, I'm interested in this bottle that you're making that looks a lot like this trademark that we have. What would you say if you were a real wise guy? You might say, I don't know anything about your trademark. I'm doing exactly what's in your design, your expired design patent. So, bye. Have a nice trip back to Atlanta.
And would that work?
Could. I mean, that's one of the basic tenets of design patents or any patent, is that it gets dedicated to the public.
And they take precedence over trademark.
That's what I would argue. I mean, I don't know if there's a case on that or not, but I would hold, if I were the judge, I would say, look, Coke, how many lawyers do you have? Now, why did you file a design patent on this thing if you didn't want to give it up? Now, it may not be that bad. It may find that the lawyers who work for Coke might be a little smarter than that. They might be very careful. And if you look at some of this, you notice that there's slight changes. And I haven't done the diligence on this, but it's possible that the design patents have evolved just enough, or the shape is designed just enough, that such that this is stretching it. This is not obvious in view of this. So in other words, this might be a patentable. This could be patentable over that. That's certainly what I would say if I were the lawyer responsible for making that decision. So you want to consider what are the ramifications? What's my business objective? What am I trying to develop? And then what are the ramifications of doing what I want or doing pursuing this strategy? Here's another example. Then we're going to do a short exercise. Moog. Does everybody know what a Moog synthesizer is? No? Yes? Maybe. Moog is in Asheville, North Carolina. They made the first electronic synthesizers that were really commercially popular. A lot of really old-time musicians like Todd Rundgren and those guys used Moog synthesizers. They came to me with this problem. They said, we make analog synthesizers. Do you really understand what that means? Analog means analog circuits, not digital. Okay? That's old school. And the problem is, said a lot of these foreign competitors, like Yamaha and the other ones, what they'll do is they will take our analog synthesizer and they'll connect a sampling machine to it, and they'll sample what the notes look like, and they'll digitize it, and they'll make a digital version of the product that we took years to develop. How do we stop them from doing that? Because we could get a patent. First of all, could we get a patent that covers digital as well as analog? Answer, yes, assuming it's not publicly known. But it takes too long. At that time, it might take 3 or 4 years to get a patent. How do we stop them? So, any ideas? Think about this. What are they doing? What is Yamaha doing that you want to stop?
The sampling.
The what?
The sampling.
Yep. What specifically, though, in terms of IP are they doing? Which of those?
Reverse the copy.
The reverse engineering, I would say that's true.
EULA.
Somebody else said it. Copying. They're copying. Right. So, at least that's what I said. So, what do you do? So, okay, so they're copying, they're reverse engineering. What do?
Copying the sound.
That's what I recommended. They said, you're nuts. How can you do that? And I said, because, I said actually specifically, why don't we try to copyright your middle C? And they said, how can you do that? I said, well, there's something about your sound that Yamaha likes. So it can't sound just like every other middle C, right? I said, that's right, there's a certain whatever to it. And I said, because we could have that tomorrow if we could put it in a form that we could then use to examine these devices as they're coming in, and you can seize the goods as they come in, if they're violating copyright. They didn't go for it. They said, that's crazy. I thought it was a good idea, and I thought it was cheap, but they didn't go for it. But that's what I mean. Look at what you're trying. What is it that would benefit you? What type of intellectual property would protect you? Most people would say, oh, just patent it. For those guys, it doesn't work. It just took too long. This product cycle was too short, even back then, which that was a fairly long time ago. So we want to do one other thing, if we have just a few minutes. What I want you to do...
We only have about
4 minutes. That's good.
Okay.
That's more than a minute each.
Excellent.
What I want you to do is take a look at these things, if you can see them from back there, and just try to... Yeah, let's pass it away. Just try to come up with different... This is the iPhone. I'd like to get this back. It doesn't work, but I'd like to get it back. Razor and Coke. And just, if we could just talk briefly about some of the things you might... What types of intellectual property and what aspects you might try to protect for each of those. I'll help a little bit. iPhone, you probably don't have to look at all that much. Okay. So what do you think? So let's do the Coke bottle first.
The freshness cap. Like
Yeah, what about the freshness cap?
the thing where you turn and it cracks
Mhm.
and it fizzes?
Mhm.
Whoever patented that is probably a pretty lucky guy.
What's the benefit of having that?
You know that the drink has never been opened,
Mhm.
and you could like say that it's like part of the experience
Mhm.
of opening
Mm-hmm.
a plastic bottle.
Yeah, I like that. What specific features, though? That's a sort of generic way of describing that freshness. You call it like a freshness tab or whatever. Specifically, if you took a close look at it, it's hard to see with it closed probably, but what specific structure?
There's a rubber seal on the inside of it.
There actually isn't. They used to do it like that.
The little plastic teeth that
Yeah,
connect
there's a
it.
thing that, so,
They're dotted in.
so when they manufacture these things, how do they do it?
The mold is like barely connected. They have like little holes, I guess.
I'll show it.
Or
You don't
maybe
have to open it.
They puncture it and they.
This is how it
How they
works.
do.
So here's the neck of the bottle. It has a little latch on it, like this. So when the unified cap is screwed in, or screwed on, it rides over this, but then it's captured behind these tabs. So when you back it off, it tears it off. So that, you're right, that was a big breakthrough. Because remember, or maybe you don't, Pop Tops were the thing really way back, and that was a huge problem with litter, right? So now you only have to worry about people throwing the whole bottle away, not the bottle and the other thing that came off with it. So it has multiple benefits, meaning what? People are going to want to do that. It's a great idea. So you want to patent that. What else? Or what, I should say, would you want to get a trademark on that? Copyright? Yeah, no. What else? That's it. One?
Oh, the bottom, the way
Possibly?
it stands.
Mhm.
It's
The fact
not,
that it stands up?
it's not a flat bottom either.
Mhm.
It's got like
Mhm.